Welcome to Kaumudy Global. The Supreme Court of India on Wednesday upheld the Enforcement Directorate's power to arrest and seize properties under the Prevention of Money Laundering Act when it dismissed several petitions challenging the provisions of the law. A bench of Justices AM Khanwilkar, Dinesh, Maheshwari and C.T. Ravikumar passed the order on a batch of 241 petitions challenging the validity of various provisions of the Act. In its order, the court also held that Section 45 of the Act was legal and not unreasonable. The provision makes offences under the law cognisable and non-bailable. It also states that when a bail plea is opposed, the court needs to be satisfied that the accused person is not guilty and will not commit any crime after release. The judges also upheld Section 24 of the Act, which states the accused person has the burden to prove his innocence. This is contrary to established criminal law principle of innocent until proven guilty. The court also said that an enforcement case information report or ECIR in money laundering cases cannot be equated with a first information report in other crimes. The judges held that it was not mandatory for the Enforcement Directorate to provide an ECIR to the accused person and that disclosing the reasons of arrest was enough. The court also upheld Section 3 of the Act, which defines money laundering. It states, whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use and projecting or claiming it as untainted property shall be guilty of offence of money laundering. In a 2019 amendment, the provisions of the Act were changed to include possession of crime proceeds within the definition of money laundering. The petitioners argued that concealing the proceeds of crime by itself should not qualify as money laundering. They argued that there should be an attempt by the accused persons to show that the proceeds of crime are untainted or legal and clean to make the act punishable. However, the court held that the phrase use and projecting or claiming the proceeds or crime as untainted money should be read as use or projecting or claiming, thereby dismissing the contention of the petitioners. On Section 44, which states that the offences under the law can only be tried by special courts, the bench said that it did not find merit in the plea challenging the provision. It does not suffer from arbitrariness, the court observed. Meanwhile, the court did not pass any verdict on the plea challenging the amendments made to the Act in 2019. The petitioners had submitted that the amendments were brought through money bills that need to be passed only in the Lok Sabha and not the Rajya Sabha. Petitioners had argued that these changes were improper since the law was outside the scope of money bills, which are meant to deal with subjects dealing with government revenue and expenditure. At Tuesday's hearing, the court, however, said that this needs to be decided by a 7-judge bench. The petitioners, including Congress MP Karthi Chidambaram, had alleged that the law is in violation of their right to liberty and right against self-incrimination under Article 20 and Article 21, according to the Hindustan Times. They also challenged the unrestrained power given to the Enforcement Directorate and the scope of the law to convert any offence into a money laundering offence. The court had begun hearing the petitions on October 27th and reserved its verdict on March 15th. In its defense, the Union government had argued that the Act pushes forward India's commitment to fight against money laundering.